No, no, no. Putem, va bene.
Some definition. Just a second, our recording is in progress. First, intellectual property is the creation, all the creation of human mind, inventions or artistic works, some symbols, names or images used in commerce. And this intellectual property is divided into parts. Industrial property, which includes inventions like patents, trademarks, industrial design, and some geographical indication of origin. And the second is the copyright, which includes artistic works such as novels, poetry, films, musicals, work of art such drawing, paintings, some sculptures, as well as architectural works. So copyright, we will speak more about copyright later, but copyrights include the right of performers in their performance. In general, the intellectual property is a broad description for the set of intangible assets owned and legally protected by a company or individual from outside use or implementation without consent. You will see this definition in our first slide. The concept of this intellectual property relates to the fact that certain products of our intellectual work should be afforded by the same rights that apply to other physical objects. And for these reasons, we have two types of assets. We have intangible assets and tangible assets. An intangible asset is an asset that is not physical in nature. Brand recognition and patents, trademark, copyrights, all of them, they are intangible assets. The other are tangible assets like land, vehicles, equipment, our company inventory. Tangible assets are physical and measurable assets, and they are used in our company operation. Assets like equipment are tangible. These tangible assets are very important for the properly working of each company. But we have various industries and various tangible assets. The first industry is manufacturing because they are a company involved to producing goods with tangible assets, including the steel industry, the technology industry, oil and gas industry. This type of industry relate intangible assets, but the intangible assets, they are typically non-physical assets used in the long term of our company life cycle. Intangible assets are often intellectual ones, and as a result, it's difficult to assign a value to them because of the uncertainty of future benefits of this asset. Intangible assets are, repeat, non-physical one, and this adds to our company future value. Intangible assets include patents, which provide property rights to the inventor, trademarks, which are recognizable symbol or phrase that distinct our company. Franchise is a type of license that a party buy to allow to have access to company brands to sell goods under their name. The most famous franchise company nowadays probably is Kentucky Fried Chicken or McDonald's. Second is the goodwill, which represents the value above and beyond a target company assets that another company pays to acquire them. And copyrights, which represent another type of intellectual property that's protected from being duplicated by non-authorized party. Depending on the type of business, intangible assets may include internet domain name, performance event, license agreement, service contracts, or some computer software, manuscript, joint venture, medical record, some trade secret. We have many companies that are famous with their intangible assets. Probably one of them is entertainment, because entertainment and media company have intangible assets such as publishing rights and essential talent personnel. Intangible assets in the music industry, for example, involve the copyrights to all of musical artist songs. Musicians and singers can also have brand recognition associated with them. The music production company might own the rights to the songs, which means that whenever the song is playing or sold, revenue is earned by the company. And although these intangible assets have no physical properties, they provide future benefits for the owner. In the healthcare industry, we have really high proportion of intangible assets, including brand names, valuable employers, or some secret receipt or secret traits for this type of company. I put here some important definition for intangible assets and typical tangible assets that include machinery or some plants. Here you have companies who have two types of assets. We already explained that tangible and intangible, and all types of assets support the operation of the company and help for to do the best revenue. In the second part, we have intangible assets in our lives too. We have many intangible and tangible property, and I will try to share with you this video. No, I don't, probably, just a second. Okay, just a second. I hope that it's running. Do you hear the music and the sound of the video?
No.
No. Okay. Just a second. I will stop share right now and I try once again to share the video.
Yes, better. And when you share it in the left, you need to click share with sound.
Share sound, yes. Yes, Maya. Let's try again.
He knows a lot about all kinds of stuff.
Yes.
Right now?
Yes.
Professor Dave explains. How would you like to be rich? In the previous tutorial, we learned about wages, but the richest people in the world don't simply save their wages to become wealthy. They buy up assets. An asset is anything of value that can be converted into money. Both individuals and businesses own assets with the expectation that they will provide a future benefit. Let's look at an example. Rosalina makes $100,000 a year in wages, but decides she wants to invest some of it. She decides to purchase some stocks, corporate bonds, and real estate. She does this because she knows that if she were to simply keep her money sitting in a bank, it wouldn't grow much. So what do we mean by grow in this context? Money certainly doesn't grow on trees, but it can grow through investment in assets. An investment is the act of redirecting resources from being consumed today so that they may create benefits in the future. In other words, it involves using assets to make money, and one of the best ways to earn wealth is to accumulate as many valuable assets as you can. In this tutorial, we are going to look at three types of assets: financial assets, tangible assets, and intangible assets. A financial asset is a claim on the property or income of a borrower. Common examples of financial assets include just plain old cash or cash equivalents like a savings account, stocks, bonds, mutual funds, or retirement accounts. A tangible asset, also known as a real asset, is one that can be physically touched. So actually, cash also qualifies as a tangible asset, but additionally, we are typically referring to things like land, houses, cars, artwork, or collectibles. For a business, tangible assets might include things like machinery or office supplies. Financial assets get their value from contractual claims on underlying assets and can therefore sometimes be considered tangible assets. Finally, an intangible asset is any asset that is not physical in nature. Examples of intangible assets include patents, trademarks, and copyrights, which all protect ownership of ideas and inventions. For a business, an intangible asset might even be something as abstract as brand recognition, which is not a physical object, yet still has measurable value. Now, some assets can be converted into cash more easily than others. Economists call this liquidity. The more liquid an asset, the easier it is to turn into cash. Both individuals and businesses have to deal with liquid and non-liquid markets. A liquid market is established with lots of potential buyers. For example, stocks are generally more liquid than real estate. This is because it's easier to sell them. These days, you can sell shares of a stock in a matter of seconds on your phone, while it may take months or even years before you're able to sell land, since there may be less demand in that market. In a future tutorial, we will look more specifically at how people invest in order to build wealth, but all we need to understand for the moment is that accumulating assets is generally the only way to truly build up wealth, since it is wealth that grows without the need for additional labor. This type of income, by the way, is called passive income.
The other part, it's not so interesting. I just want to share with you the main difference between tangible and intangible assets in our life, not only in our business. And we will continue to the big parties of intellectual property are divided then to patents, copyright, trademark, franchise, and trade secret. All of them are different, really specific, and all of them take part of this big group of intellectual property. We continue with patent. It is an exclusive right granted for an invention, which is a product or process that provides in general a new way of doing something or offers a new technical solution to a problem. To get a patent, technical information about the invention must be disclosed to the public in a patent application. Patents pose many questions. First is what right does a patent provide? What and when we need to apply for a patent? A patent owner has the right to decide who may or who may not use the patent invention for the period in which the invention is protected. What kind of invention can be protected? Patents may be granted for inventions of any field, mostly in the technology sector. How long does patent protection live? Protection is granted for a limited period. It's not forever. It depends, but generally it's about 20 years from the date of application. So if you want to patent some of your inventions, okay, you have 20 years of guarantee that no one else can use it if you don't want to use it. The third question is a patent valid for every country? No, because they have territorial rights. In principle, exclusive rights are only applicable in the country or region in which the patent field is granted in accordance with the law of this country or area. When applying for a patent, you choose to apply for national, European, or international level. It is good to make some informed decision because they are very different procedure to obtain national, European, or international patent. How are patent rights enforced? Patent rights are usually enforced in a court of the initiative of the right owner. Why are patents useful? Because they provide protection for individuals or company by offering them recognition for their creativity and the possibility of material reward for their invention. And for this reason, if you can make the money for something, okay, it's valuable asset for you. The second question is interesting for me. Can I obtain patents but to keep the invention secret? Some people scared that if they go to the patent application, all of their invention will be ruined. But unfortunately, despite this fear of having your invention disclosed, patents are issued by patent office in exchange for full disclosure of the invention. And generally, the details of the invention are published and are made available to general public. It is recommended to discuss my invention before patent application. No, it's not a good idea. Because in general, any invention which is made public before an application is considered like not an invention, but prior art. And this prior art is different category. So it's not recommended to discuss anyone your invention. Can I patent some application? Because we live in the technology industry, patents can be obtained for the technology, of course, and application can be patent too, but they meet some criteria of novelty like other products. And how much it costs to receive this patent? It's different. It's not for free. It depends about your type of application, national, European, or international. So it depends, and you must see all the taxes that you must pay. Can I obtain a patent worldwide? The short answer will be it depends, but probably it's very difficult, very hard procedure. For me, it's no, because each country has its own patent system. And to protect some invention globally, you need to obtain a patent for all country. if you think that it is important for your business, it's possible, but it's really hard to obtain it. And is the patent relevant to my business? Only the business owner can answer this question. For some industry, it is absolutely obligatory to do it. For others, not so much. So it depends by the owner's decision. Why to make some patent? For to receive exclusive right, of course, to return investment, to increase in negotiation power and positive image for your enterprise. Of course, all is due for the positive brand image. Before look the video, I just to share that for the copyrights and the patents. No, first I will give you the video, and after that I will speak for the copyright, because right now I just try. Maya, could you just a second for the
Okay,
video?
just a second.
Patents allow us to take a long-term view, I think, first because they do provide some protection and some security in our investment. It can take a fair amount of time, a lengthy time, for these things to kind of play out and actually demonstrate real value in the marketplace with our clients. But having that patent in your hand gives you some confidence that down the road you'll be able to leverage that technology. And you don't see that until it actually gets out into a product and has a real use in some client's application solving their problem.
It's not enough to say, I innovate. You have to say what you're going to do will matter. It is really a very important part of the culture. You value innovation, but not for the sake of writing down a patent, but for rather the sake of capturing some nascent idea very early in the cycle that goes on to change the world.
By writing down a patent, you have to publish what it was that you did. It's not a trade secret. It's actually to open up markets for many people to play. And we think that's really important, that patents enable the free exchange of information actually better than if we kept things as a trade secret.
We are now at a defining moment where fruits of our labor have real potential to solve practical problems, problems that might save lives or enhance lives in real world.
And after this short video, we go to copyright part. Copyright refers to the legal right of the owner of intellectual property. In simple terms, copyright is in the right to copy something. This means that the original creators of products and anyone they give authorization to are the only ones with the exclusive right to reproduce the work. Copyright will give creator much right, and copyright ownership gives the owner the exclusive right to use the work with some exception. When a person creates an original work in material form, then automatically own the copyright in it. Many type of works are eligible for copyright protection. Audiovisual work, such as some TV programs, movies, online videos, sound recordings, musical composition, some written works, lecturers, articles, books, music composition, visual works like posters, paintings, sculpture, video games, to computer software, other type of specialized software, musicals and dramatic works. I share with you this video too. It's really short.
Today, it's easier than ever to explore media. Movies, songs, books, games, and pictures are available at a click. Sometimes we pay for them. Sometimes they're free. Sometimes there's a paid version and a free version. When we find media online for free, there are 3 reasons why that would happen. First, the artist chose to make it available for free. Sometimes when this happens, the artist being a responsible digital citizen is steering clear of copyright infringement. To do that, we need to understand what it is.
Show me what you mean.
Sure, I'll give you some examples. Passing around or sharing copyrighted media on peer-to-peer or torrent sites, especially sites that encourage uploading and downloading without permission, that's copyright infringement. Checking music CDs out from the library and copying them to your phone or MP3 player to add to your music library, that's copyright infringement. Same with watching or listening to the latest movies or songs, using sites that stream music and movies without the artist's permission. Sometimes it's tough to know if a site is legit or not. But if a movie just came out in the theaters and you find it streaming or for download for free, it's likely illegal and distributed without the creator's permission. And using file storage sites to allow your friends to download copies of your music library and movies is also a copyright infringement. File storage sites like Dropbox, Plex, or Google Drive are great for helping us keep track of all our important files. These might include our music and movies, but file storage sites should not be used as a means for sharing copyrighted creative work. These sites prohibit this kind of illegal sharing.
Hey, I think I know one. What about using a recording app to make copies of music from an online streaming service?
Right, that's infringement too. And guess what? There are benefits to avoiding infringement and searching out trustworthy sites instead. For starters, you know that you're getting your creative content legally from businesses that deal fairly with the artist or creators. It's the right thing to do. You also don't have to worry about getting caught and possible penalties you might have to pay for breaking the law. On top of that, illegal file sharing programs and sites often have malware and other bad stuff you don't want. When you use trusted sites, you don't have to worry about malware that could corrupt devices or dig for your personal information.
Okay, I get there are benefits to being a good online citizen, but sometimes it's hard to know where to go to get media legally. How can I find sites that respect artists' rights?
Click through to the next video to find out.
Svetle, you're muted. You're muted, Svetle.
Sorry, I forgot to. Okay, thank you. And it is important to note that if you share or use some content or publish some content online, your content could be removed in response to a copyright, even if you have indicated the copyright owner, or you have not received any revenue for this content, or even if you have noticed similar content elsewhere on the internet, or you have purchased the content, including of paper or digital copy, or you have recorded this content from TV, cinema, or radio, or you have copied content from a movie poster or photo. And one really simple example of what is copyright. Probably imagine that you own a flower shop in Greece and you want to place an ad in a local magazine. You find a really nice photo of the most popular Greece flower in your area, and you want to use this photo to advertise your flower store. Before sending this file to the magazine, you notice that the photo is copyrighted with the proper sign, and the owner does not allow this free use. Therefore, you are not allowed to use the photo in your advertising. If you want to use photo for free, you should search online for photos that are free of copyright. It can be used for a commercial purpose, for example, in some online database. And when using such material, you must not seek for permission from the rights to the holders to use this photo for your flower shop advertising. About the copyright law, you see all interesting things in our presentation. That copyright law protects creators for their original material from unauthorized duplication. Every original work can be protected by copyright. And in the United States, some works are protected until 70 years after the death of their owner. About copyright, how it works, it works really differently in online space. But when someone creates a product that is viewed as original and that require mental activity and creativity to create, this product automatically becomes an intellectual property that must be protected from unauthorized duplication. Unique creation can be design of website content, musical lyrics, composition, all kinds of design, and including, of course, computer software. About protection, the copyright protects original works of authorship, while a patent, here is important, while a patent protects invention or discoveries. Ideas and discoveries are not protected by the copyright law, although the way in which they are expressed may be. So here is the big difference between copyright and patent. We have three basic requirements for one work can be protected by the copyright. First is original. To be original, a work must merely be independently created. The second is a work of authorship. And third is fixed. To meet the fixation requirement, a work must be fixed in a tangible medium of expression. We have three interesting things for the copyright. And after that, we have trademark, but about the trademark, I'm sure that you distinguish many of trademarks, because trademarks is an easily recognizable symbol or a word that denotes a specific product. It legally differentiates a product or service from all others, and many things can be registered as trademarks, your company names or company logo. This is the most common things. A trademark can be anything that allows customer to distinguish good or services from those of another. Like trademark, we can register a word, a logo, some shape, some color, a combination of colors, sound, multimedia, motion, or hologram too. The top 10 very recognizable trademarks in the world are first is Amazon, after that it's Apple, following by Microsoft, Google, of course, Visa, Tencent. I'm not sure about the second, but Facebook like a trademark is 8. 9 is McDonald's, and MasterCard is the 10th. I'm sure that you will recognize all of these famous international logos, because I'm sure that all of you know what is this Apple sign, the sign of Coca-Cola, Nike, Google, Adidas, Amazon, YouTube, and even that we do not have words here, we have protection of logos, because all of these logos are protected. According to way of presentation, we have word marks. A word mark consists just of words and letters. We have sound brands. We have color or combination of colors. We have stamps, position mark, multimedia, and hologram. According their purpose, the trademark can be individual, collective, or certificate. An individual trademark is intended to denote the product of one person. The collective ones, this type of trademark distinguish the goods and services of the members of an association from the products of other persons. And certificate allow the holder to exercise control over the quality, material, method of distribution, or all the indicated goods of service. According to their territory, the trademarks can be national brands, brands of European Union, and of course international registration. They are different too. All of these examples that I give you here are international. According subject of protection, we have trademarks for goods, trademarks for service marks, and trademarks for goods and service. About trademarks, if we distinguish some type of them, we must register them. How long does it take to register a trademark? We have here several stages to submit a request, of course, to be verified by the authority, provision and time limit for opposition, because they may occur, and registration. In the European Union or in the USA, the registration of trademarks is around 7 or 8 months, but the procedure is around 1 over a year. About frequently asked questions concerning trademark, one of them is what happens if someone objects to the trademark registration. It is possible that during procedure, a third party will object to the registration of your trademark. This does not mean it will not be registered, but the procedure will simply be suspended until the dispute is resolved. In such a situation, it is possible to use the service of lawyers to mediate and to resolve the dispute. If you don't need this trademark no more, when you can request this termination of trademark registration, the validity of the trademark is terminated if you refuse or express your refuse to termination. But validity of one trademark is around 10 years. The other interesting question, are there any fees to request this trademark registration? Of course, there is a fee and taxes and all of this. And this is dependent if your trademark must be trademark of European Union, just national or international trademark. We will go to the next step about franchise. It's a very popular mechanism for working in the business. I give a little bit of definition. A franchise or franchising is a method of distribution of products or service involving a franchisor who established the brand's trademark or trade name and a business system, and a franchisee who pays a royalty and after an initial fee for the right to do business under the franchisor's name and system. Technically, the contract binding the two parties is the franchise, but that term more commonly refers to the actual business that the franchises operate. The practice of creating and distributing the brand and franchise subsystem is most often referred to as a franchising. I'm sure that you know many franchise name, because is a multiplier of business success and help many entrepreneurs to develop their own retail chain by launching their own business under the brand name or existing successful chain. Franchising involves working under a well-known brand and a proven business model with proven know-how. For example, Subway, Pizza Hut, KFC, McDonald's, Hampton Hotels, Ramada Hotels, all of them, they are made by the principle of franchise. Type of franchise, we have two, business format and product distribution franchising. Franchise opportunities these days are usually known as a business format. When you are the franchise in a business format franchise, you operate your business using the principal trademark that belongs to the franchisor. This is usually the name you will use to identify your company to the public and commonly referred as a brand. So if you want to open some KFC in Bulgaria, okay, you will need to acquire this business format franchise and to open your KFC or McDonald's or some Subway probably in Bulgaria. We have here branded products, of course. This make franchise very popular. And about second category of product distribution franchising. In the most cases, companies that are looking for an alternative to the business format will select a structure known as a product distribution. In this type of franchise, the franchise is normally called a dealer or distributor. Dealers are given the right to use the franchisor's name when selling their product, but they are not given the kind of support such as access to property system and training that would be available in the business formats franchise. And as a result, franchise normally pay some sort of fee for the minimal number of products they need to make a profit. We have here the relation between one and another party. That we have valuable assets, we have absolutely support of the brand name and the secure contacts and secure contracts of the franchising. I'm not sure if you hear me. We continue with trade secret. The trade secret is a reference to the business ownership of a formula, compilation, program, device, technique, or process that provide a competitive edge. And the Coca-Cola receipt is one of the most famous business secret. It is protected by an intellectual property right called a trade secret. In the worldwide, we have KFC herb and spices because it's one of the another top trade secret. The Google search algorithm is another one famous secret. The Big Mac of the McDonald's special receipt is one of them. And the trade secret includes the sales method, the distribution method, consumer profiles, advertising strategies, list of suppliers and clients, and manufacturing processes. I will try to share this video with you.
Ever wondered what goes into Coca-Cola's secret recipe or Google's algorithm? Well, you'll probably never know because these are trade secrets. Companies of every size use trade secrets to get a competitive edge and protect their intellectual assets, industrial processes, strategic plans, customer data, and so on. Does that mean the fajitas recipe at your mother's restaurant qualifies for protection as a trade secret? Well, maybe, but she would have to take appropriate steps to keep it secret. Trade secrets are not limited in time, have no registration cost, and are effective immediately. But unlike patents, they may be used by others if discovered, and are more difficult to enforce. Ever wondered?
I think that we already spoke more about intellectual property. I give you example because everything I said so far is subject to intellectual property. But in brief, who owns intellectual property? Generally, it is the creator of a work. It's an owner. What is intellectual property used for? It's used just for commercialize an invention, and entrepreneurs plan to take the intellectual property to market in some form. And I give you many examples of what is intellectual property. Here it's the famous GDPR or General Data Protection Regulation. It is an European Union law with mandatory rules for how organizations and companies must use personal data in an integrity-friendly way. Personal data means any information which directly or indirectly could identify a living person. There is a name, phone number, address, and score book example of personal data, interest, information about past purchases, health, and online behavior is also considered like a personal data, and it could identify a person. Personal data is the heart of the GDPR, and however, many organizations are still unsure exactly what personal data is. But before to continue to personal data, for GDPR, it's important that this is the only and same law through Europe that use personal data must in line with integrity-friendly principle. Use of personal data must be legal. Use of personal data must be respectful, and personal data breaches must be reported within 7 and 2 hours. The GDPR consists of personal data, controller, destruction, and sensitive data. Personal data, I say that is the heart of GDPR, but however, really from time to time, I'm not sure what is can be defined as personal data or not. The GDPR clarified that information is considered personal data whenever an individual can be identified directly or indirectly by reference to an identifier such as a name, a number, location data, or other identifier, or to one or more factors specific to the physical, psychological, genetic, mental, economic, cultural, or social identity of the natural person. Names aren't always considered like a personal data. You might think that someone's name is a clear an example of personal data. It's literally you define you as you, but itself the name probably Karen Jones may not always buy personal data because there are many individuals with that name. When the name is combined with other information like address of Karen Jones or place of work of Karen Jones or phone number, in that case, it is a personal data because by knowing this data, we can identify the unique Karen Jones. As I try to explain, it can be hard to certain information needs a GDPR definition of personal data. There is some short list of things that could be considered like personal data, either or they own or in combination with additional information, biographical information or current living situation, date of birth, social security number, phone number, or email address, look, appearance, behavior, workplace data, information about education, including monthly salary, tax information, student number, private and other data, including political opinion or health or medical history. All of this is can be considered like personal data. The difference between personal data and sensitive data. We can ask what personal data is considered sensitive. According to European Commission, some personal data is considered sensitive and they are subject of specific processing condition. It's personal data revealing ethnic origin, political opinion, religious or philosophical beliefs, trade union membership, biometric data, generic data, health-related data, data concerning person's sexual life or sexual orientation. These are absolutely sensitive data. About controller, what is a data controller? Data controller is a natural or legal person who alone or jointly with others determines the purpose and means of personal data processing. The role of data controller is to determine who shall be responsible for compliance with data protection rules and how data subject can exercise their right. About the destruction of data, the process of destroying data stored on hard disk, some tapes on other form of electronic media. They must be completely unreadable, and after destruction, they cannot be accessed by unauthorized purpose. So if you want to delete some personal information for your desktop, and if you think that is necessary or sufficient, no, it's not. Because the deleted files still in your computer, still in your recycle bin. And if I have access to your computer, I can check on the recycle bin and to use this personal data. So to destruction is to absolutely erasure of existing of this personal data. About the practical implementation of GDPR, it's not so easy because the new regulation specifies rules, processes, and technologies required to make European resident personal data secure, accessible, and to be used properly and well documented with consent. But any organization that supplies good or service to European residents or simply collects data of them, regardless of where this data is used or stored, must comply with the GDPR practical implementation. Compliance isn't optional, and don't make the mistake of assuming that the information system and process compliant with the current regulation are GDPR compliant, because probably they aren't. The GDPR has around 90 pages of detailed requirements and around 98 or 99 article of specification. And for this reason, it will be difficult to comply with GDPR requirements and obligation in some cases. So you must be very detailed according all requirements. According to European Commission, your company and organization need to appoint DPO. What is DPO? Data protection officer. If you need it, and you must have one if your company operates with big data. About the action plan for implementation of GDPR, we have to create alignment. Of course, after that, to be absolutely aware about all the European requirements, to notice and to notice all the communication in your company, to keep in mind individual rights, to have legal basis for processing, to have data security, and to be aware for eventually breaches, to design a good privacy, to have, if needed, data protection officer, or to be aware for all kind of data transfer. So implementing GDPR in your company it's not so easy, but it's mission possible if you read carefully all the European law and documentation about that. And I'm sure that you are a little bit tired after this long presentation about GDPR, intellectual property, and all specific things. But if you have some question, you can write in the chat, or you can ask me. And don't forget to follow the link that Maya sent in the chat about the evaluation form. It will be really nice of your part if you can fill it. Any questions?
Thank you, Svetla. If you have any questions.
Probably no. So thank you everyone to be part of our topic today.
Don't forget to fill the evaluation form, and also if you want to fill the questionnaire, self-assessment test.
Thank you, Vitlana. Okay, I will say goodbye to everyone. Thank you for being part of this, and I wish you a nice and lovely evening.
Thank you very much. Have a nice night.
Thank you for your participation. You can find our webinar in our platform. So thank you very much. Thank you, Svetla, and to all participants.
Thank you.
Thank you. Sorry for noisy here, but I can't.
Don't worry. Bye-bye.
Thanks. Bye.
Bye. Thank you.